On June 9th, 2005, the Israeli Supreme Court has handed down a very dramatic decision, some may argue one of the most dramatic decisions ever. I am talking about the decision which rejected petitions against Sharon's disengagement plan from Gaza. Yes, Gaza again. I prepared this presentation way back, and this is only coincidence that Gaza again is on the news due to recent events. That petition was dramatic for various reasons. First of all, on its merits, the decision which basically found the disengagement plan to be legal removed the final obstacle from Sharon's government at the time in implementing the disengagement plan, and as such opened the way for the disengagement that took place only a few weeks later. Today, some may say that, or speculate that due to that plan or the disengagement, we had to deal with Hamas rockets in the past summer, but this is only a speculation, so I leave it to you for you to ponder. In any event, that decision was dramatic in at least two more aspects. Number one, procedurally, Israeli Supreme Court decisions, like any other decisions in common law countries, are usually given this following format. There's a leading justice or a leading opinion, then concurring judges sign and concur with the opinion, and if you have dissenting judges, they write their dissenting opinion. In this decision, which actually was given out by 11 justices, which is also unique because in Israeli Supreme Court, unlike the United States Supreme Court, only 3 judges sit on each particular case. Only unique or difficult or complex issues are removed to a wider bench. This was one of them, 11 justices out of 14. But the interesting fact was that in this specific decision, there was no leading opinion, meaning there was one, but it was signed by 10 justices collectively, as opposed to one judge writing the decision and others joining them, under which you can know who wrote the judgment and who concurred. Here, we had a judgment, a leading opinion, with 10 justices signing as a collectivity. And then Judge Edmund Levy, who passed away this past year, who dissented. I have never seen such a precedent in the Israeli Supreme Court, and I think it's pretty obvious that the idea behind it was, A, maybe to conceal that specific judge who wrote that opinion, on the one hand, and on the other hand, to add more legitimacy to that opinion, so to, quote unquote, to make it look as if this was a product of a collective organ, the Israeli Supreme Court. Nonetheless, I think anybody who has read some legal opinions of the Israeli Supreme Court from those years could trace Justice Barak's very visible footprints in that opinion, even though, as I said, it wasn't signed by him solely, but the entire bench, aside from Justice Edmund Levy. The decision was dramatic in one more aspect. As you know, in 1967, Israel seized control over Judea and Samaria, the West Bank, as some may call it, and the Gaza Strip. This decision was handed down 37 years to the day after the end of the Six-Day War. And for the first time, I would say, after a long process, which I would soon delineate, the Supreme Court has said the following, and I quote in a loose translation. We have accepted, we recognize the state's attorney's position, or its historic position, as has been presented to this bench and prior benches in the past few decades, that the laws of belligerent occupation apply to Judea and Samaria, more specifically the norms of the Geneva Convention, and therefore we excuse ourselves from debating whether that's valid or invalid, that assertion of the Israeli state's attorney. Nonetheless, added the court, we leave it in a question mark whether the state attorney can withdraw its position or decide to change its custom and to not apply the norms of belligerent occupation. This note, which was basically not part of the ratio of the judgment, because nobody asked whether Israel, the state attorney, can actually remove or change his mind about the applicability of the Geneva Convention, I think implicitly sends a message that whether, if, and when the state decides to deviate from its traditional position, that would be somewhat difficult. Somewhat difficult for them to do so. Now, this is very, very interesting, since Israel's official position since 1967 to this day that it is not an occupying power in Judea and Samaria and the Gaza Strip. Nonetheless, we see here a almost official position within Israeli legal system that applies the norms of belligerent occupation to Judea and Samaria. So in Hebrew there's a saying, "Lalechet im le'argish bli," which loosely translated means to go dressed and feel naked. Here we see the opposite. You basically go naked and feel dressed, meaning Israel, we've reached a situation in which Israeli legal actors, jurists, judges, attorneys, legal scholars take it as a given that the norms of belligerent occupation apply as is to Judea and Samaria and the Gaza Strip. So I think it is interesting to understand how we came about this situation or legal situation. And in order for us to do so, we need to embark upon a legal journey, I would say an historical journey, in order to assess and evaluate what is the legal status of Judea and Samaria under international law, and how does that apply to the Israeli legal system. Now, when I give this presentation to different crowds, I ask what should be the point of departure for our legal history or a journey into legal history. And I get various answers. Some say Avraham Avinu, Abraham the patriarch. Some say the entry of the Jews into the land of Canaan some thousands of years ago. Some say 1948. And if I would ask you, what would be our point of departure, you would probably say? Any ideas? Where would I start the legal analysis of the status of Judea and Samaria?
End of World War I and the League of Nations.
Exactly. Exactly. So that's probably right. Yes. So I would start with the British mandate for Palestine, which we endorsed the Balfour Declaration. But that is the first. Right, something before that, yes. But the British mandate to Palestine is the first, I would say, binding legal document that was given to the British and established the mandate for Palestine. Two more comments before I continue in this brief legal journey. We're embarking upon a legal analysis of the status of Judea and Shomron. It is a legal analysis and a legal analysis only, meaning when an individual or a nation face a dilemma, a moral or political dilemma, the legality of it is one aspect of it. It's one factor that a nation or individual should consider before engaging in an act or avoiding an act. We all know that some things are immoral, even if they're legal. I mean, we would all agree that cheating on your spouse is immoral, I hope, but it's still a legal act. Or we would all agree that some things are illegal and are still not even morally desired, but morally required. For instance, if you have an injured person and you have to drive and cross a red light at 2 o'clock in the morning in order to rush him to a treatment, that is still, it's the morally desired thing to do, but it's an illegal act. So the legality of an act is not equivalent to whether that act is desired or undesired from other perspectives. Nonetheless, since we are talking within the legal arena, and especially in this specific settings, which is basically the Lawfare project, meaning we are engaging in law war, we have to understand that the outcome is very, very important. Now, some Israelis may say that even if, for instance, the Israeli presence in Judea and Samaria is illegal, under international law, we couldn't care less because we have moral and religious and cultural and historical ties to those pieces of land. And that's too bad that it is illegal, but some things are illegal and morally just. And some may say that even if Israeli presence is very legal and even not permissible, it is a morally unjust presence. So keeping that in mind, we should now go back to the legal analysis. And another comment is that under international law, there is no strict definition of what constitutes as occupation. There is no definition, unlike other bodies of law, where you can open up a section or a provision and see the definition of a legal situation. But I think if somebody, if you research or survey the body of norms that regulate occupation, I think we could induce two underlying impulses that, once understood, can help us understand what is occupation. And by that I mean that the norms that apply to occupation typically look for, protect, I would say, or can be better understood according to two principles. A, securing the basic and humanitarian rights of the occupied population. B, respect and securing by the occupying power the sovereignty, the temporary suspension of the legitimate sovereign that was removed from the occupied territory. If you keep these principles in mind, you can grasp a coherent understanding of the law of occupation. And we'll get to that later. So in 1922, July 24th, 1922, the League of Nations authorizes the British mandate, that gives them the mandate for Palestine. In Article 2 of the mandate states as follows. For the purpose of the mandate was that the mandatory should be responsible for placing the country under such political, administrative, and economic conditions as will secure the establishment of the Jewish national home, etc., and also for safeguarding the civil and religious rights of all the inhabitants of Palestine, irrespective of race and religion. The British received the mandate for Palestine for one purpose only, which is the establishment of a Jewish national home, nonetheless, while securing individual rights for any other groups residing in that territory. As you all know, the mandate initially was given to the British for both sides of the Jordan River, the West Bank and the East Bank. Later on, actually very early on, the British have given the East Bank to the Hashemite kingdom, and the League of Nations has later amended the mandate to reflect that decision. Fast forward 20-something years, in September 1947, the British declare that they are withdrawing, they're returning the mandate to the UN, and they have failed to fulfill the purpose of the British mandate. At that time, the League of Nations is no longer in existence. After the Second World War, the League of Nations dissolved and the UN took over. Article 80 of the UN Charter, I would say, tunnels in all recognized rights and legally binding instruments giving out that have been previously recognized by the League of Nations. So therefore, the Jewish right for a national home in Palestine is still a valid right, even after the succession of the League of Nations by the UN. So as a result of the British declaration that they have, they plan to evacuate Palestine and terminate the mandate, on November 29th, 1948, the General Assembly of the UN votes on the partition plan. It is a common mistake to think that the partition plan was a binding resolution, legally speaking, and that the State of Israel was established as a result or on the grounds of the partition plan. The partition plan, legally speaking, is in no way a legally binding resolution for at least three reasons. Number one, Articles 10 and 14 of the UN Charter specify that the General Assembly has no binding power to pass any resolutions. It can only recommend on various decisions or and its opinions. Only the UN Security Council has binding force to pass binding resolutions. And in fact, the partition plan, or that vote on the decision plan, and that decision specifically called for the UN Security Council to take measures to implement the partition plan and to take it from a recommendation to make it into a binding legal resolution. But the next day, despite the fact that the Jewish leadership and the Jewish agency, where actually hosts, I think, this event, at least physically, have endorsed the partition recommendation, the Arab leadership has rejected it. And therefore, the recommendation by the UN General Assembly has evaporated and did not materialize into anything binding because the UN Security Council did not follow through. And the clashes in Palestine, which led to the formation of the State of Israel, have basically made it unnecessary. After the Independence War in 1948, Israel was able to capture more territories than the partition plan initially envisioned. And Israel has signed in 1949 a series of armistice agreements with its surrounding neighbors. Relevant for this discussion is the agreement with the Hashemite kingdom, Jordan. Now, as I said earlier, the Jordanians had no claims to Palestine, or at least the west, everything west of the Jordan River, because they received from the British a part of the land, and they had no claims to what was supposed to be a Jewish national home. Nonetheless, they invaded Palestine and have signed with Israel the 1949 Armistice Agreement. Two provisions are very important for our legal analysis. In Article 2, the parties insisted of adding the following language. No provision of this agreement shall in any way prejudice the rights, claims, and positions of either party hereto in the ultimate peaceful settlement of the Palestine question, and the provision of this agreement being dictated exclusively by military considerations solely. And then Article 6, this agreement is agreed upon the parties without prejudice to future territorial settlements or boundary lines or to claims of either party relating thereto. In fact, it was the Arabs who insisted on this more than the Jews, because they wanted to maintain any claims they had to the State of Israel as a whole. They weren't willing to recognize its legal validity, and therefore recognizing the armistice borders as a valid border would implicitly recognize the State of Israel. Nonetheless, there was no doubt that the green line, which was basically the 1949 Armistice Agreement line demarked by a green highlight, was seen by all as a random armistice line which was governed by military considerations alone. A very striking and interesting example used by one of my colleagues, Major Daniel Reisner. He talks about Kever Rachel and Kibbutz Ramat Rachel. Kibbutz Ramat Rachel is in the outskirts of Jerusalem, and Kever Ramat Rachel is in the outskirts of Bethlehem. Now, the only difference, and Kibbutz Ramat Rachel is considered part of the State of Israel by international law, and Kibbutz Ramat Rachel is considered to be under occupied, part of occupied territories. The only difference between Kibbutz Ramat Rachel and Kever Rachel, which are basically maybe 2 miles apart, is that the Arab Legion from Jordan was stopped somewhere in between. And the Armistice Agreement has demarked that line to be the green line. But there is no either a political or a legal argument to claim that Kever Rachel is any less Israel than Kibbutz Ramat Rachel. And nonetheless, the popular wisdom or the conventional wisdom suggests that Kever Rachel is occupied territory and Kibbutz Ramat Rachel is not. Both of them were outside the boundaries delineated by the partition plan. 1950, Jordan annexes Judea and Samaria, the West Bank, and immediately the Arab League convenes and condemns Jordan for doing so, because Judea and Samaria are perceived by the Arab League as to be part of the to be belonging to the Arab nation as a whole. And in a clarification letter by the government of Jordan, they respond and say that they only annexed Judea and Samaria, and they hold it in trust until the Palestine question will be resolved, that they have no legal claim or no Jordanian claims to Judea and Samaria. In fact, no country in the world, even in no Arab country, has recognized the annexation of the West Bank, but for two states, England and Pakistan. So, legally speaking, up until 1967, we have a piece of land, Judea and Samaria, which have been invaded by someone who has no legal claim to it. Nonetheless, it is the has effective control over those territories. Yet it is not legally recognized by international community. 1967, in the Six-Day War, Israel enters the West Bank, and the Jordanian soldiers and troops are pushed back east of the Jordan River. Israel seizes control of Judea and Samaria, and from that day on till today, failed to either annex it or form any other form of political entity in Judea and Samaria. Immediately following 1967, when Israel has captured, after Israel's captured Judea and Samaria, there was a question of how to address this unique situation, as some legal scholars, I think it was Julius Stone, coined that specific territory as terra nullius, a void, a legal void, meaning a country without a sovereignty, because to that point, until that point, there was no legal sovereign in Judea and Samaria, yet Israel has taken control over it, did not annex it. What is this in terms of legally? How would you frame it legally speaking? Under what legal drawer would you put it? How would you categorize it? Some leading scholars at the time have, and Meir Shamgar, which was the Attorney General at the time and later Chief Justice of Supreme Court, have phrased Israel's official position, which was supported by some significant international scholars, which basically says as follows: Israel is not an occupying power in Judea and Samaria, since there was no legitimate sovereign in Judea and Samaria, and there is no doubt that as a state, Israel has more legal right to acquiring title in Judea and Samaria than any other country in the world, and therefore it cannot be considered as an occupying power, and therefore the rules of belligerent occupation should not apply to Judea and Samaria. Nonetheless, said Israel's official position, we are willing to bind ourselves to the humanitarian provisions of the international laws of belligerent occupation, even if we do not see ourselves as, strictly speaking, as being bound by them. This position was proponed and supported by Julius Stone, by Stephen Stribble, later president of the ICJ, the International Court of Justice in Hague, by Eugene Rostow, Dean of Yale Law School, and by many other legal scholars. And that has been Israel's official position from that day to this day. Simultaneously, after 1967, the Israeli Supreme Court has opened its doors for petitions of Arab residents of Judea and Samaria, where they petitioned against administrative acts and military acts of the Israeli military regime, which was placed in Judea and Samaria. This is a very interesting phenomenon, which I will talk about in a minute, which couples with the expansion of the right of standing under Israeli legal system, which I think is similar to what's happening in the United States, where in the past you had to show a immediate link to the cause of action. In Israel nowadays, anybody who can demonstrate a very weak loose, if at all, to a legal claim is allowed to present it in front of the Supreme Court. The point was that those petitions within Israeli legal system based many of their claims upon the laws of belligerent occupation, namely the Hague Convention and the Geneva Convention. And here's the point. The state attorney's responses to those petitions has been as follows. It always had an opening statement. Despite the fact that our official position is that we do not see ourselves bound to the laws of belligerent occupation, nonetheless, we're willing to answer this petition as if these laws apply. And that, in some way, allowed all parties to shove off the question of whether these norms actually do apply, legally speaking, to the situation in Judea and Samaria. And so, for a number of years, these petitions to the Supreme Court, the High Court of Justice in Israel, have been flowing more regularly to the Supreme Court. At some point, one of the justices, Justice Vitkon, had a comment and said, in one of the footnotes to the opinion, he says, I think the state attorney is misunderstanding something. This is not an arbitration institute where the parties can decide to apply whatever legal system or legal rules they want to apply upon them. You have to take a stance whether you think you're bound by these legal norms or not. That comment, even though was not a part of the main judgment, was just an arbiter, nonetheless, I think from that point on, the state attorneys basically probably at some point even dropped their opening remark about them being not officially bound to the laws of belligerent occupation. And from that point on, the Israeli Supreme Court has again and again reviewed administrative acts and the petitions against the military or against the government related to Judea and Samaria based on the laws of belligerent occupation. Until in 2005, as I said, in the decision handed down by the Supreme Court, the court mentions that whether or not that was a valid or a legally binding decision, the question of whether Israel or the state attorney could now step back and say, oh, you know what, we changed our minds. We do not want to be bound again by the laws of belligerent occupation and specifically the Geneva Convention. The court says, well, I don't know if that's possible at this point. Didn't make a decision, but he sort of left the question hanging in the air. An interesting phenomenon is that despite the fact that, as I said, the question of whether the laws of belligerent occupation apply as is to Judea and Samaria, Israel has been the #1 country in the world in terms of amount of precedents and interpretive judgments relating to the Geneva Convention more than any other country in the world, for various reasons. There's a tendency for countries not to allow judicial review of its own acts based on international legal norms. Israel has allowed that. Another obvious reason is that Israel has been in Judea and Samaria for almost 40 years, so which by definition produces more legal litigation that revolves around the situation there. But it is a striking fact that Israel has been willing to submit itself to legal norms that it seems no other Western country, including the United States, has been willing to do until this point today. Now, so what are the laws of belligerent occupation? As I said, there are two underlying impulses. One is the protection of the civil and humanitarian rights of the occupied population, which Israel said it's willing to be bound by. And I think that was not such a unwise decision because the legal argument that the laws of belligerent occupation do not apply is obviously, I think, also motivated by political reasons. And Israel's willingness to apply the humanitarian provisions of of belligerent occupation reflected the authenticity of its argument, meaning Israel was not rejecting the laws of belligerent occupation because it wanted to avoid or to be free to conduct war crimes. On the other hand, it was willing to accept those provisions that apply to basic rights and protection of the occupied population. So the thought was, I think, that by this kind of de jure rejection of belligerent occupation laws, by de facto application of at least some of those provisions, showed the authenticity and of that legal argument made by the Israeli officials in Israel and abroad. But the fact is that as a result, Israeli courts have applied the laws of belligerent occupation as a whole. The other set of bodies of regulations governs, as I said, respect for the regime that has been suspended from Judea and Samaria, from the occupied territory. For instance, an occupying power is banned from changing the laws of the occupied territory unless it's completely necessary for security reasons, because it is seen to be a temporal trustee holding it in trust for the suspending power. For instance, the occupying power is banned from changing the legal system or the judicial system or legal infrastructure, because it is seen, again, as a temporal suspension of the previous sovereign. But if you think about the situation in Judea and Samaria, these norms do not fit squarely, because there is no legitimate sovereign. So who exactly do you want to respect? The Jordanian rule, with his no doubt was illegal? Why not change the rules in Judea and Samaria if they are no longer adequate? But the fact is that Israel avoids doing so because of its de facto acceptance of the laws of belligerent occupation. And I'll give you one striking example of how absurd the situation is. Judea and Samaria is the only place in the world today the Turkish land law from 1867 still applies. Even in Turkey, it was amended and rejected. In Judea and Samaria, it still applies. It's an anachronistic and irrelevant land regime that still governs real estate transactions in Judea and Samaria. Why? Because Israel does not want to change any governing laws in Judea and Samaria unless it's necessary for security reasons. Judea and Samaria does not have a land register that you can go land register where you can go and look up a plot and a parcel number and see who has title to those pieces of land. It is still governed by the old system of the Ottoman way of by personal names, ownership and titles to to parcels and plots. Meaning, if you want to know who owns the land, you have to have a survey. You have to ask people who has a contract to that piece of land. You have to make sure that that contract is legal, and it's very difficult to ascertain who has title to that piece of land. Sometimes the maps are very old, but it seems as if time stood still in Judea and Samaria for at least 40 years in terms of advancement of the land regime. Zoning is still governed in Judea and Samaria according to the Jordanian and previous regimes, British and Ottoman law. The procedures are very cumbersome and very difficult, and as a result, there is no doubt that many absurd legal outcomes prevent the development of Judea and Samaria for both Israeli population and Palestinians who reside there. As Ben has mentioned previously, the Levy Committee appointed by Mr. Netanyahu about 3 years ago was asked to offer a legal reform in Judea and Samaria which would advance it to a modern day era. And indeed, one of the most, I would say, pressing recommendations of the Levy report was to change some of the laws, specifically the land laws in Judea and Samaria, to make it adequate for the 21st century. Another example which would strike most of you being US residents and citizens is that Judea and Samaria is the only place in the world that the Jordanian law that prohibits sale of land to Jews is still in place. Even that law, Israel failed to revoke because it did not want to change laws of the occupied territory unless it is needed for security reasons. So Israelis who want to buy land in Judea and Samaria privately need to form a company in Judea and Samaria which will be registered in Jordan, and through that buy land. You cannot own land in Judea and Samaria if you are a Jew or an Israeli citizen. Even that law still applies to Judea and Samaria today. This is one of the absurds or the absurdities that still govern the situation in Judea and Samaria. So what we have seen are basically two legal paradigms of conceptualizing the situation in Judea and Samaria. The official position of Israel is that Israel is not an occupying power in Judea and Samaria. Obviously, I didn't mention it, but I think it's a well-known fact that this position is rejected by many, many, many legal jurists today. I don't think this should be taken as a surprise. The area of international law, maybe more than any other areas of law, is predominated by political and ideological motivations. So I think we should not be taken back by the fact that most or many legal jurists in the international community do see Judea and Samaria as a occupied territory. Nonetheless, Israel's claim that it's not an occupied territory is a valid claim and is definitely a claim that's worth defending. So on the one hand, that's Israel's official position, but de facto, within Israeli legal system, Israel moves around as if it is an occupying power, and as such, I would say, in the pursuit of protecting or overly protecting and safeguarding norms from international law, has attained some absurd and irrational conditions which curtail the possibility of leading normal lives for both Palestinians and Israeli citizens in Judea and Samaria. I'm asked quite often whether that's reversible. Put aside that comment of the Supreme Court, which is not legally binding. Whether Israel could change the course it has taken from 1967 with dealing with the Judea and Samaria. I think it is. I think it is because everything that I said now is not something new. This is something that has been consistent with in legal scholarship since 1967. The only thing that's new is that the other narrative, the narrative that sees Israel as an occupying power in Judea and Samaria, has become very vocal in the international community, very aggressive. And I think that if we do see it as this as a lawfare project, meaning as a goal that people who perceive themselves as actors in the legal arena want to pursue, it is possible. It is possible by changing and sort of, I would say, reinstating this basic truth within Israeli legal community, but also sounding them to the international community. I think recently in the past couple of years we've heard these voices more and more often in the international media. But this is something that is worth repeating over and over again. If the Arabs can make false claims and repeat them over and over again until everybody thinks they're true, we definitely do not have the luxury of avoiding truth and just giving in and submitting to the other side and leaving out arguments which are in our favor. I'll open now for Q&A if anybody's interested. Okay, so I think you've asked 3 questions. Number one was that your comment or question that is a crazy situation. How did we come about that, which is true. It is a crazy situation. And in fact, we've seen it just now in the Gaza campaign, where Israel has taken the most severe interpretation of international legal norms on the expense of its own soldiers and civilians. I read an article in some blog a few weeks ago that measured the ratio of air bombardments versus civilian casualties in modern warfare just to give you an example, so if Israel has bombed Gaza over 1,200 times, there were about, let's say, 100 civilians, innocent civilians killed, the ratio about 1 to 11, 1 to 12. US and other military campaigns produce a ratio of 1 to 1 or 1 to 2, meaning air assaults versus civilian casualties. It is crazy. It is crazy that Israel has a tendency to apply it, to bind itself to norms which are unprecedented. You're right, on the money. What was the reasoning behind it, you ask? I think that the reasoning was either naivete, meaning if we apply at least the humanitarian provisions of laws of belligerent occupation, we will get credit points for that, and we can get away with our argument that the other bodies do not apply. Someone once told me that international opinion is not like a credit history that you can accumulate and use it whenever you want to. When Israel is doing something, no matter how much credit is accumulated, after a day, it's gone. But I think that was the thought behind it, and also I would say the dynamics of the legal system, where once you repeat something and it's a paradigm, then people tend to forget that the underlying justification is very, very shaky. And lastly, your last question was?
So what are we left to do? Do we have to set up a whole new legal system?
Right.
Or
so the question is whether, what's the alternative? Yeah. This precise question I was asked by the Levy Committee when I appeared before them. And they asked me, okay, so Dr. Arnon, so what do you anticipate, or what do you suggest would be the other legal norms that apply? So I would say the answer is twofold. First of all, we have to recognize that some complex situations in life do not fit to a standalone or a cookie-cutter legal rubric. This is one of them. Meaning, yes, there is no other situation where a country is occupying for over 40 years a land that belongs to no one, that it has legal claims to. It is unprecedented as a matter of life and as a matter of legal fact. Yet, even if we do not apply the laws of belligerent occupation, there's no doubt that humanitarian law applies. Israeli administrative law applies by the mere fact that the organs of the country move around Judea and Samaria. So anybody can review, an Arab resident can review administrative acts based on Israeli administrative law. It doesn't have to appeal to a Geneva Convention. So, and also 47 or 40-something years of presence in Judea and Samaria has produced a set of legal norms which are related to the international legal norms of belligerent occupation, but are not always one-to-one compatible, which govern and should govern the new, I would say, emerging or the legal paradigm that should govern Judea and Samaria. Yes, it is a long, we're trying to take a U-turn here. It's not that easy. But if we believe and understand that it's the right thing to do, then at least we have something to aspire with and not, I would say, not bang our heads against the wall when we go out and we fail to pose out the number one argument in our favor, which you rightly said is a shame. Sorry. Okay, so great question. You've asked me how does the Oslo Accords affect my analysis? So the short answer is yes and no. I would say the number one legal submission that Israel has given in the Oslo Accords is the fact that it, for the first time, recognized the right of the Palestinian people to, I would say, a state in Judea and Samaria. As you know, Palestinians were Jews and non-Jews before the establishment of the State of Israel. Only in the past few decades, Palestinians is a surname for the Arab or the Muslim or Arab residents of Judea and Samaria. But until the Oslo Accords, Israel never recognized this right. And it is a legally interesting question whether a party to a contract can withdraw recognition of rights, even if the parties breach the agreement. Meaning, if you and I sign a contract and the contract is terminated, it is questionable whether I can now say, you know what, I now do not recognize what I've already declared as a recognizable right. So that was a major, I would say, a legal significance of the Oslo Accords. But the Oslo Accords also contain provision that said that the settlements, the boundaries, and the legal regime issues would be suspended until the final agreement to be signed after the interim Oslo Accords. If you recall, the Oslo Accords were supposed to be on for 5 years, and then the parties should have. So in some ways, it didn't change, specifically to areas C and B, which are under Israeli control. So areas A in the Oslo Accord, which is the heavily populated Arab towns and villages, which Israeli life does not take place there anyway, those questions are of less significance and are therefore irrelevant to this analysis. Okay, so you're asking about the legal status of the Gaza Strip today or before the Oslo Accords or before the withdrawal? Because Gaza is a little bit different because Egypt never annexed Gaza as opposed to Judea and Samaria. So in some sense, it's even easier, the claim that Israel took it from no one is even easier. Nobody wants Gaza, not even the Egyptians. And I would question whether even the Palestinians themselves want Gaza. So there is no doubt that analysis applies to Gaza. After the disengagement, the thought was that Israel would no longer be seen as an occupier in Gaza because there is no presence there. And that also turned to be false. I mean, the world continues to see Israel as an occupying force in Gaza. But since there is no Israeli presence, then at this point, we couldn't care less about the legal regime or the land regime or any other laws that apply to the Gaza Strip because there is no Supreme Court petitions coming in from Gaza. Actually, there are a few. There used to be a few. You know that after the Oslo Accords, and until a few years ago, there used to be an industrial zone in Kerem Shalom and other places which basically allowed Palestinian workers to work for Israeli companies, etc. So more than once, Palestinians who've been injured due to Hamas rocket fires that shelled their places of employment have asked for Social Security money from the Israeli legal system because they were employed by Israeli, and guess what? They got it. So these are Palestinians who have been injured by their own fire, and they're getting my tax-paying money for their injuries. So this is another, I would say, crazy illustration of a situation we're at. Yes, please. Yes, the valid question was that since it seems obvious that the Oslo Accords have been breached, then they're no longer valid. So I have two answers for you. Three. First of all, you're right. Secondly, Israel failed to declare that the contract has been breached, and therefore it's no longer binding. Some say that it should. I'm not sure, because if there's an ongoing breach, then maybe at any point in time, the statute of limitation doesn't even start running because it's a constant breach. But even if Israel would have done so, as I said, the biggest, I would say, our biggest problem from my perspective is the fact that we recognized a Palestinian right to a state in Judea and Samaria. We didn't say in the entire Judea and Samaria or where, but we recognize that right. And I'm not sure it's a valid question whether even if you breach a contract and you terminate it, whether you can withdraw from recognition of rights that you've already granted. So in that sense, it's an interesting legal question. As I said, we may agree that even if Israel has no legal right, who cares? Or the other way. But legally speaking, that's a question. Yes, please.
Keeping it within legal grounds, who is your best opponent on this? And what is your best opponent's argument? And where are you vulnerable? Where's the weakest point?
Right, okay. I honestly think that the legal argument that I just presented, legally speaking, is stronger than any argument out there, even if I am politically biased, number one. Number two, my weakest point is as follows. Well, that's very interesting, Mr. Arnon. But when you have something that moves around like a duck, that sounds like a duck, and squawks like a duck, it's a duck, right? You have a population here that has no citizenship, that's under military control. That's occupation. Face it. You're trying to square the circle. And therefore, even if technically speaking, it doesn't fit into the formalities of occupation, this is occupation, or at least the underlying principles of occupation should apply, because in fact, de facto, you have large numbers of people who are under military regime for over 40 years. These people have no passports. They're under military control. This is occupation. Convincing? Wait, let me answer. Well, part of my job, I'm also a regular lawyer, and sometimes I have cases where someone comes to me and says, "Can we take this?" I said, "Well, I'm sorry, you missed. statute of limitations ran out 2 days ago. I said, what? Only 2 days ago, but I'm right. I said, you're absolutely right, but the law has criteria. The law aspires to be a mathematical enterprise, and therefore, if you don't fit the legal criteria, you're not there. Therefore, even if it looks like a duck and sounds like a duck, it is not a duck unless it's a duck in essence. So therefore, even if it looks like an occupation and sounds like an occupation, well, it doesn't meet the criteria of occupation as I or many legal scholars see it. So I would say, and back to Brooks' question, this could also explain why Israel has basically gone halfway through. It was willing to bind itself to the humanitarian provisions because, after all, there is no doubt that some aspects of occupation apply. You have population under military control. We need to safeguard their rights, and Israel has done so. But nonetheless, other sets of norms within belligerent occupation are not relevant. For instance, respect of the Jordanian rule, or Jordanian law, or Ottoman law, for that matter. So that I think would be my response to my best opponents. The question was whether the fact that you have checkpoints in Judea and Samaria doesn't mean that this is a situation of occupation. You have checkpoints in many other parts of the world, but the difference is that the checkpoints between Canada and the United States, for instance, are checkpoints or borders between two sovereign states. And a Canadian citizen has citizenship in Canada, and a U.S. citizen has citizenship in the United States, unlike the situation in Judea and Samaria, where the checkpoints do not mark a border, or they're basically based on security interests, which justifies them. But then again, you're right, it justifies it, but that's why it's not the same as a border between the two sovereign states. But I think what matters, and here I'm going to the political arena a little bit, if you allow me, is that people should ask themselves, what is the root cause of this conflict? Is that really the 1967 war, meaning Israel's occupation, quote unquote, of the territories? Is that really the root cause of that? And if that's the root cause, then obviously the solution would be to maybe give it back to someone, or the root cause is different. I think it becomes, at least for me, more obvious today than it was in the past, that the root cause is not that at all. Israel has been vulnerable to terror way before 1967, and with the looking and zooming out a little bit outside Israel, looking around us, I think we realize that this is a battle between two civilizations. That Israel happens to be at the forefront of one of these battlegrounds, meaning the surrounding population and the Arab world simply does not want the state of Israel to be existing. And if you realize that, then you realize that any succession you make in order to appease one faction or another faction, there will always be an excuse to wage war on you for another reason. Look what happened in southern Lebanon. For 18 years, Israel had a military occupation of the security buffer zone in southern Lebanon, and there was chaos. Let's evacuate southern Lebanon because we're giving them excuses. So we've evacuated, and Hezbollah is right on there. Gaza Strip, the same thing. I think we would have been more cautious when in doing commercial transactions. When facing these kind of evidence, Israelis should not be expected to experiment with their own country, their own and their lives, just for the sake of pleasing some vocal arguments in the international arena. It occurred to me that watching CNN last night, we see the butchery that's in Iraq now, and I could not ask myself. This reminds me. Forgive me for the comparison of the Holocaust. Our Jews were killed in Europe, and we said, how did the world not do anything? And we always have this tendency, today it would have been different. Well, today, there's a genocide taking place in the Middle East, and it seems to me that the world is not, aside from paying lip service and doing some trivial things, is not really, really willing to sacrifice their resources to save a people. It is embarrassing. Embarrassing for me, for us as human beings, to realize that despite our ambitions, we haven't gotten that far yet. We haven't developed for a real sense of solidarity that would allow us, it would be natural for us, or for the UN to intervene right away and to save people for death. The question is whether the British mandate was actually tried, or this argument has been raised in validly binding legal institutions. The question is no. The answer is no, meaning it hasn't. And I would say there are two reasons for this. First of all, the area of international law is a more fluid legal discipline than other legal areas. And therefore, it is bound for interpretation and subjectiveness more than other areas of law. I mean, a major opinion written by the ICJ about the separation wall in 2004, about the Israeli wall that is constructed in Judea and Samaria, has basically said that Israel is an occupying force in Judea and Samaria, and it didn't even address the British mandate. That wasn't a binding legal decision because it's only an advisory opinion. If you calculate the fact that it was the members of that court was an Egyptian, Pakistani, and somebody else, and as I think it's quite obvious to see why the outcome was what it is. So there is no legally binding resolution on this issue. And I would ask you, you're not a lawyer, you told me before, but when a client comes to me and says, this is my real life case, I want you to protect me and present the best legal argument you can for me, if I would tell him, but you know what? The other side actually also has a binding an argument, and I actually like his argument, and therefore, do you mind if I tell the court that I support the other side? He would fire me, and rightly so, because I am hired to defend him. This is even stronger case when not only I'm not hired because this is a cause too big to be hired for. I really believe, and many others really believe, that this is not a fake argument. This is a real argument. If you have a title for land which is 200 years old, it could still be a binding legal document. The fact that 80 years have passed doesn't diminish from its legal validity, especially once I attempted to describe the legal path that this document has been taken. And this legal argument has been proponed by major international legal scholars, right? The majority of legal scholars, many reject that because it looks like an occupation. Nonetheless, if we want to confine ourselves to pure legal analysis, I think that case is stronger than any other legal argument. And definitely, I have no obligation as an Israeli to accept my opponent's argument, knowing who he is, who they are, and after assessing their counterclaim versus my claim. Thank you very much.
We would be pleased to send a complimentary DVD of this program to anyone who wishes to support Shalom TV with a tax-deductible gift of $36, double high or more, to the nonprofit organization Jewish Education in Media. Simply visit the Shalom TV website homepage and click on the Donate button to make a donation by PayPal or your credit card. And please indicate the program for which you would like a DVD. Or you can send your tax-deductible check made out to GEM, Post Office Box 180, Riverdale Station, Bronx, New York, 10471. And again, please remember to indicate which program you would like to receive on DVD with our compliments. And we thank you for your kind support.